Hello everyone, this is Gary from Fantastic Fundas, and this is the last lecture on the fundamental rights. And in this lecture we will be talking basically about the right to constitutional remedies. See, no right is ever complete. Right gets completed only when there is a judicial remedy, that is, you have some sort of remedy where if you do not get right, you can go and ask for your right. Right, so right is completed when you have a remedy. Okay, now article 32 of our constitution provides for this constitutional remedy, right? And under this, see, you can move the Supreme Court under this article, and obviously you have to file a petition for it. And Supreme Court can do, it can issue few things, right? It can issue directions. Okay, it can issue directions, or it can issue orders, or it can issue writs. A Supreme Court can do these three things whenever a case is filed before it, right? Now, what kind of writs can be issued by order means nothing, right? Simple thing. For example, it can ask for compensation, ask someone to pay the compensation for the thing, right? And directions means that you have to do this, do that. Simple, right? It's nothing much. The word itself is self-explanatory. But then when it comes to writ, it is always confusing for a lot of people. So we will talk about the writs now. Right now, there are just 5 writs which can be issued by the Supreme Court, and what are these writs? We will talk about each of them separately. First of all is the most important writ, and this is known as the also the writ of habeas corpus. Okay, habeas corpus. Corpus word, like you must have heard of corpse or the body. Okay, corpse, the dead body. So because corpus is basically the body. Okay, and habeas means have, so you can have the body or let the body be free. It basically translates into let the body be free. Body be free. Right now, see what happens, that it is a remedy available to a person for to whom person, any person who is arrested. Okay, who is arrested or even detained, right? For without any reason, illegally, who's illegally arrested, that person can file this writ petition, right? It means you can let the body be free, or to have the body. That is what this habeas corpus means. And the court issues this writ, which has to be obeyed by the detaining authority. For example, court will say, police court will ask the police to let the person whom they have arrested free. Okay, now this basically is in other words, is simply protecting the person against the arbitrary detaining or arbitrary imprisonment. Okay, this person is protected under this right. Okay, that and basically it is and once the person is arrested, right, he must be brought before court for a formal charge. Okay, now if the charge is considered valid, the person is tried. Okay, the person is charged in any criminal case, and after the charge is put on, the person is tried by the court, under which evidence and all are given, and then person is convicted. Okay, now if not, then the person, if this is not done, right, and then the person must be let free by the court. Okay, and if okay, now but there is a one exception to this, and that is under detention law, as we read under article 22, that a person can be detained, right, for a period of 3 months, right, and but they have to tell him about the charge, and beyond for purpose of detaining, you have to take the permission of the court, right? And it's pretty much simple. Okay, now if you want to move to high court for this purpose, you have to do that. Same thing can be done under high court for under article number 226. Okay, and who can file this petition? This petition can be filed by any person, whosoever, by the person who is detained, arrested, that person himself. So this can be filed by a person himself, or so it can be filed by someone on his behalf. Okay, someone on his behalf, right? And disobeying the writ is, if you, let's say, police does not release the person, even if the Supreme Court issues the writ, then that will amount to contempt of court. That will amount to contempt of court. Okay, this is how it goes, right? Now, second writ that I'm going to talk to you over here, this is the known as the writ of mandamus. Mandamus, as the word itself sounds, the sound of the word, आवाज कैसे है? It says do this, mandamus, something like this. So what it basically literally means, it means that we command, we order you to do this or do that. Okay, this is how it is. For example, you go to police station, a police person is there, SP is there. Okay, and he does not file an FIR, even if after you say and the crime has been committed. Okay, so you can go to court and court will order him to file the FIR through the court will issue the writ of mandamus and order him to file the FIR. So that is, we command you to do this. Court is commanding a person to do certain thing, right? So the writ of mandamus is basically it can be issued against public or semi-public authority, right? And asking him to do specific public duty. It has to be public duty. A court cannot ask a private person. Supreme Court cannot ask a private person again, to do this or do that. And they cannot issue a writ against the writ of mandamus. Okay, and this is basically in a way a judicial enforcement of a public duty. Okay, right, judicial enforcement of public duty. And but then if the authority who has to do the work, it has discretion to do some work, then that public duty then this writ of mandamus cannot be issued. Okay, and same goes for high court. Under article 226 there also writ can be filed, right? Now to whom it is issued? For example, it is issued to the government or any subordinate court. Okay, subordinate court, or it can be issued to some government company, right? Whatever that is related to the state, basically commanding them to, and it can ask them to act or refrain from doing something, right? They are ordered basically from acting in a particular manner, or acting or do not act in a particular manner. And mandamus basically is less wider, it has is less scope compared to habeas corpus, because under habeas corpus habeas corpus can be issued to private person also, but mandamus cannot be issued to private person. This is only for the public or the semi public. Okay, that is the difference. And mandamus cannot be issued to the president or the governor of the state, or for when they exercise their powers under article 361, right? Because of 361 mandamus cannot be issued against them, and it all, right? So basically it's a discretionary remedy, and high court can even refuse if alternate remedy exists. There is some other method of doing it, then Supreme Court or High Court can refuse this. Some other method is there of doing the same work, some other method, then they can refuse this writ. That is how it is. Now so basically, to sum it up, there are just two qualities of duties which can be enforced. Number one, it must be, as I said earlier also, public duty, number one. And number two is that the duty over here, it must not be discretionary. Okay, so there are two conditions to sum it up for the purpose of mandamus, discretionary. Okay, now let's talk about the writ of prohibition. That was mandamus. We move to prohibition. Now in the writ of prohibition, basically it is a writ issued to some inferior court. Okay, and or let's say to one is inferior court, and number two is semi judicial body, for example a tribunal. To them this writ issued of prohibition, right? And basically it tells them that you do not have jurisdiction over this particular issue, so you are prohibited from exercising your power. Because why all this? Because you do not have jurisdiction. This is what the writ of prohibition is. Okay, now while mandamus basically commands activity, okay, prohibition commands inactivity. That is the basic difference. Mandamus is about activity, right? Now mandamus is about activity. You have to do this, right? And essentially prohibition is about inactivity. You cannot do this, right? And it's available only against judicial or quasi-judicial authorities, right? And not against public. Now this is again definitely not against the public officer who is not vested with a judicial function. So this is only, prohibition can only be against a person who is having some judicial function and not against anyone else. Okay, now then comes the fourth writ, and that is writ of certiorari. Okay, Certiorari. Now certiorari, this is a Latin word again, just like habeas corpus. This means to be informed. Okay, to be informed, right? This means that it basically refers to the order a court, right? It refers to the order of the court, right? It issues to a lower court or lesser tribunal even to transfer the case to another body. The reason being that the original body did not have the jurisdiction, and there was some kind of irregularity involved. The higher court basically whatever, if there is some proceeding by the lower court, that it can be quashed to certain extent. To make it easier for you, it is basically a writ issued by a superior court, obviously Supreme Court, High Court, by a superior court to inferior court, okay, inferior court, which is of course under its jurisdiction, right, asking it to certify and return certify and return the record in a particular case, okay, whatever the whole case is, it has to certify it and just shift it to somebody else as per the order, right. Now it is read within the scope as same thing as prohibition, right. Now the difference is that in certiorari, it is issued after the proceedings begin, okay. So basically in this, the proceedings are quashed. They can be quashed as per the wish of the Supreme Court, High Court, to whatever extent they wanted. So proceeding is quashed under certiorari, right. And under this, what happens, that the case is transferred to the competent court and transfer it to the competent court, right, or it's quashed, and then it goes to the competent court. If the judgment has already been given, then judgment is already delivered, then this can be order for the quashing, okay. And prohibition is just you're stopping it, you cannot proceed ahead. That is prohibition, if there is any confusion in mind of anyone, okay. Now the following, the circumstances in which prohibition or certiorari can be issued. I'll give you just few examples of that, where prohibition certiorari can be issued, right. When judicial body, right, was not having jurisdiction, as I talked about to you already, then there can be prohibition or certiorari, right. Prohibition, the proceeding has not yet happened. In certiorari, the proceeding has happened, so it is quashed or transferred. Prohibition, you are stopped right at the beginning, right. And when there is excessive jurisdiction, right, first of all, it has to be about judicial body. Second, there is case of excessive jurisdiction, okay. Even in those cases it is filed, right. And when the principles of natural justice are violated, I've already talked about what are the principles of natural justice. I told you about two principles, that one must not be a judge in his own cause, and no one shall go unheard, okay. No one shall go unheard. These are the two principles of natural justice, and it acts on the basis of law that itself is struck down, okay. Some law was there, now that law is void, that is illegal. So some action is issued, and in those cases also you can have prohibition or certiorari, depending on the case to case, right. That much detail is enough for you. You need not have extreme detail. The law books and books have been written on these 5 writs only. And then 5th writ, which I'm going to talk about, is the quo warranto. So whenever you're appointed in a public office, suppose you become IPS officer or IS officer, now you are appointed this officer under the warrant of the government, okay, warrant of president, in fact, right, warrant of president, that you are appointed, right. Now quo warranto is, quo means question, okay. It's a questioning, under what warrant, right, under what warrant are you holding that post. Sometimes it so happens that a lot of people say that I am an IPS officer, but in reality they are not into police. So such people can be punished. Against such people this writ can be issued, or right. Or by what authority, right. It enables inquiry into the legal claim of a person which a person asserts to public office, and to oust him from such position. Somebody says I am the election commissioner and he is just not leaving the office, then against him this writ can be issued, that under what authority he is holding that position, okay. Now then he has to prove, the person against whom case is filed, that he holds this authority under this office. Now the office of public is there are few conditions, that it must be a public office, only then this writ can be issued. You cannot issue a writ against the manager, let's say chief managing director of Reliance, that how, under what authority you're doing. No, you cannot do that, okay. And then it is created by the statute or by constitution itself, so that means this the quo warranto writ can be issued only in the case of statutory authority or in the case of constitutional authority, okay. And number 3 is, the respondent has asserted his claim. The respondent must say that I am holding this office. He must resist that office only then this writ can be issued, okay. Now even this can be issued, right, even before the person assumes the charge of the office, right. And the fundamental basis of the writ is that public has interest because of somebody person is holding that authority. So this is how because you're holding that authority, that because I have an interest in it, public in general has interest, so writ can be filed, okay. Now question is, can this writ be filed against some ministerial office? No, answer is no. And in the case of the ministerial office, this writ cannot be filed, okay. These are the 5 writs that we have. Now I'll just quickly wrap up this lecture, and I'll just talk about a few remaining articles which are of not of much importance too, but much not of much importance to you, but then these articles are otherwise you must be aware at least 33, 34 and 35 articles. That was article 32 in which those rights were mentioned. Okay. And yeah, there's one more thing about article 32 I just missed to mention, and that was the this right of constitutional remedies, right? It shall not be suspended, right? Unless, except as for if there except for the provision of the constitution, this article cannot be suspended. Okay, the constitutional remedy hai this one, right? Now there comes article 33, and article 33 basically lays down the power of the parliament to modify any rights, any fundamental rights with respect to armed forces. Okay, armed forces have restrictions on certain restrictions on their fundamental rights, and parliament can, by passing a law, control these rights, right? Right. So in their application to basically armed forces, number one. Number two is any force which is charged with the maintenance of public order. So that is there. And number three is person who are employed in any bureau or any other organization, for the purpose of any intelligence or counter intelligence. Okay. So all these things are there, right? For example, some person goes to of raw goes to Pakistan and does some spying in Pakistan. Okay, now that person comes back, right? Now he can be denied certain fundamental rights by making a law to this extent. This is written in the article 33. That will not be that law will not be invalid because of article number 13, which says that any right under article and under part 3 of the constitution cannot be abridged. Okay, that cannot be shortened. So this person his rights can be curtailed, right? And lastly, number 4 over here is that the person who is in anyhow system employed or connected with the telecommunication system somehow. Okay, even his rights can be curtailed to certain extent. Okay, and this telecommunication system which was set up for some force or bureau or organization. Okay, bureau or organization, right? Even he can be denied some fundamental rights. So this is the law over here. This is important thing you must be know. This is article number 33. Then article number 34 is very simple. It is nothing. It just says that whenever there is martial law in force, okay, martial law in force, then the rights given, the fundamental rights, that is part 3, they can be restricted. Okay, that is given over there, right? And then article 35 is there, which talks about I have many times said that a law can be made, right? For example, in just article 33 I was telling you that fundamental rights can be restricted under article 33 by making a law. Now the power of making these laws is given by article number 35, right? Now, so overall, that was about fundamental right. Now fundamental right has few more topics associated with it. One is the emergency topic, like it's suspension of fundamental right during emergency. I will be doing that topic when I do the emergency. Okay, and after this, there's one more thing, right? There can be question in your paper on the criticism of the fundamental rights in India, right? I hope you can write about it. It's a very, very simple thing. I'll talk to you about, like, for example, various criticism. For example, article 19 mentions the word morality. There is no clear-cut definition of what is morality. That is the criticism. And then there is the word public order so many times used in fundamental rights. You can say what is meaning of public order. These are not clear, because they can have very wide meaning. If they have very wide meaning, that can lead to misuse of those clauses by the government, and that can lead to curtailment of fundamental right, which is against the spirit of the constitution. Okay, that will create a lot of problem, right? And then freedom of press has not been differently mentioned, right? Freedom of press has been given it is same as the freedom of any individual, right? There is no difference, right? Now we need to do this because press has a bigger role, right? Recently, President of India Pranab Mukherjee also said that that the press keeps the conscience of the society. That is important, right? And then in the case of child labor, now it is high time that we amend it and make it that no form of child labor can be allowed, not even in the non-hazardous industry. That is another criticism of fundamental rights in India. Okay, and then the right to property has been taken away. That is another criticism, right? And then so many articles are there in the fundamental right itself which curtail the scope of fundamental rights. Okay, now the conclusion is, most of the population in India, how many people are actually enjoying these fundamental rights? They are breached over daily. Somebody's religious rights are breached daily. People have a lot of complaint about this. Okay, and then then the issues of religious rights are there, and issue of interpretation is there. Okay, and it's high time that we specifically laid something about Article 21 while keeping Article 21 intact. And Article 21, we have so many interpretation rights. So what do we do about it? Like Article life and personal liberty. So it's something, it needs to be further clarified. Okay, now with this, the part 3 of the Constitution ends, and now in the next lecture we will be beginning with the directive principles of state policy. So that was all about today's lecture, and now just wanted to make two very important announcements. And the first thing is that I just wanted to thank you all whosoever you have shared my videos on various social media, on Facebook, Twitter, Google Plus, everywhere. Thank you so much from my heart, and it is my humble request that you please keep on sharing this video in future also. जिन्होंने आज तक नहीं share की, if you really like the video, it's my humble request, please share it with others. That gives me encouragement to make better videos and ज़्यादा वीडियोज़, एंड आई कैन कवर ज़्यादा सब्जेक्ट अगर आप इस वीडियो को शेयर करते हैं. एंड सेकेंड थिंग इज़ that this is for your own benefit. If you really like these videos and you want that updates about the new videos should come into your mailbox, you can subscribe to us. You can see the subscribe button over here. You can click on us and videos will come right into your email box. आप हमें सब्सक्राइब कर सकते हैं. अगर ऐसा करते हैं तो वीडियोस डायरेक्टली आपके मेल बॉक्स में आ जाएंगी. बस इतना ही कहना है. दैट इज़ ऑल, एंड थैंक यू फॉर वॉचिंग द वीडियोज़.